Duterte pulled his country out of the International Criminal Court. After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso, understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges leveled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defense has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte, or even indicating his participation in or control over any one of the 49 incidents alleged in the document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability leveled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in a prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Number one. Interviewee, at least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee. Yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one, witnesses who said, the PNP never said kill those people. Another quote, from what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated
Sorry, wala pala akong mic. Well, dito mga clear, lumalabas. Sinasabi, in general to ha, isa-summarize ko lang ng konti. Habang naghihintay tayo. Kaya nawala ito. Yan. Lumalabas dito mga kaklear, na marami sinasabing prosecution. Ang daming speeches. Pero doon sa kanilang sinabi, parang hindi naman nila mapakita yung masasabi talagang direct participation ni dating Pangulong Duterte. So maraming speeches, pero it's more on, kumbaga, point blank, hindi mapakita kung sino. Diba? Kung meron daw dapat, sinabi na doon sa kanilang statement kung sino. Lack of clarity daw, at sa kanyang observation is mukhang political hyperbole lang yung mga balita laban kay dating Pangulong Duterte. So yun lang. So far, mga clear, yung pa lang yung ginigiba niya. Wala pa siyang sinasabi na patunay na, halimbawa lang di ba nabanggit dito si Espinosa, si Mayor Espinosa. Wala naman pa siyang nasasabi na walang relasyon si dating Pangulong Duterte. Wala pa. Sa pagkakamatay, di ba? Kay Espinosa, wala pa rin siyang, kasi ang dami, di ba? Ang dami ng present ng prosecution. Kung tatandaan natin, may pinresent pa na sa na hinahabol, na parang alam na alam niya ito, totoo hahabulin. Remember that? Natatandaan niyo yan? Parang may hinahabol, yan. Parang ang dating is papatayin. Diba? Parang papatayin yung hinahabol na yon. Okay? So hanggang sa nagkagulit sa may bantang palengke yata yun. So, wala pa akong nakikita or nadidinig na sinasabi ni Kaufman doon. Kumbaga sinasabi niya dito, ito ay hindi masasabi na ang pangyayari ito ay pang lahatan. Kundi nakatutok itong pagkitil, no? Siguro pag-solve sa problema. At kumbaga may purpose kung ba't ganon. Pero hindi niya sinasabi na mali ang ginawa, diba? Mali ang ginawa ng kapulisan. Hindi. Para may purpose doon, pero hindi pang lahatan yun. May target lang ng mga criminals doon sa mga nangyari na yon.
The fourth supposed indication of a common criminal plan, and that is set out in paragraph 27, and mentions that on the very day that the former president appointed Ronald De La Rosa Bato as the chief of Philippine National Police, De La Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modeled after Davao City's policing strategy and was directed at the neutralization of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralization as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralization forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald De La Rosa Bato within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, De La Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question, "Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights?" Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very 16 of 2016, which states should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, Maître, je vous remercie, Kaufman, je vous remercie beaucoup.
Thank you, Counsel. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that will be good. Thank you very much, says Judge Motok. We will take a break now and resume at 11:30. Thank you very much.
Yes, ayan mga ka-clear, no? Yun, umaga, lahat dito ng sinasabi ngayon, hindi pa naman tapos ni Atty. Kaufman. Lahat lang ng mga binanggit ng prosecution, ginigiba niya lang yon. Wala pa siyang sariling ebidensya. Basta yung mga sinabi lang ay kumaga pinapalabo, di ba? Kumaga lahat ng pagbibintang nyo, hindi nyo ma-i-connect yung mga speeches si dating Pangulong Duterte, di nyo ma-i-connect sa totoong patayan. So lahat ng speeches niya, lahat ng sinabi niya ay political hyperbole, di ba? Ano na siya? Exaggeration, ha? So doon lang. Tapos sinabi niya dito, itong pinakahuli, meron ditong parang tungkol sa project double barrel. Okay? Pero mismo dyan, sa project double barrel na yan, ang nakalagay dyan, ito ay gagawin, based on the law. It will be done legally. So it's the same, the evidence, according to Kaufman, na ginamit ng prosecution na, pero bakit hindi nyo sinabi itong patungkol na there should, parang kumbaga may kulatilya, may kondisyon. Magkaroon man ng proyekto, meron mang program na double barrel, mananatili pa rin daw itong proyekto ng double barrel base sa batas. Yan. So parang pinapasinungalingan ni Atty. Kaufman na hindi intentional yung patayan. Kung may nangyari, masipa hindi naman yung dinidinin na nagkaroon naman talaga ng patayan, di ba? Meron ng double barrel at kung magkakaroon man ng ganong klaseng insidente, may namatay, di ba? Na mga drug dealers o drug users, it's because may nanlaban. Or kung ano man ang ginawa ng administrasyon noon ni dating Pangulong Duterte, lahat yon ay base sa batas. Hindi sila lalabag. Ha? Sabi dito, ano nga, ano ba yung sinabi niya? Taken out of context lang din daw yung tokhang. Kasi kumbaga sa Tagalog, ang tokhang daw ay katok at saka luhod, something like that. Or, so, ha? Parang katok, pakiusap. Yun katok, pakiusap. Hangyu, parang gano'n. Pero hindi pagpatay. So, yung tokhang na word daw is taken out of context. So, but anyway, mahaba pa to mga kaklino. Hindi ko alam kung, kung iisipin mo, pagka sa ganito klase kasing mga pag-start ng mga palabasan ng ebidensya, normal yun mga kakliran. Kahit sinong lawyer, talagang ang gigibain lang niya dyan, itong sinasabi ng prosecution. Dapat lumabnaw. Kasi ang criminal case naman, mga kakliran, it's supposed to be beyond reasonable doubt. Alam naman natin, dapat walang mikatiting na pagdududa na siya yung gumawa ng krimen. So, kapag ka pinalabnaw mo yun, at biglang nag-isip, hindi naman nasabi dito, nilalabas naman dito, lumalabas naman na yung mga ginawa ng DDS o yung panahon ni dating Pangulong Duterte. Lahat naman ay inayon sa batas. Pinakita dyan na may self-defense, mga ganon. So, dapat mapakita na yan. Kaya lang, mga kaklir, kasi in general naman kasi yung nabanggit ng prosecution. May mga nabanggit lang naman sila in particular na situation, like kay Mayor Espinosa, para hinog, di ba? Sino ba? Kay Kian de los Santos ba nabanggit nila? Basta kumbaga, sila nagbanggit ang prosecution in general na nangyari, including the admissions. No? Sa speech, ang siguro mga ito lang yung makikita nating kakaiba, no? Di ko alam kung take upin ba ito ni Atty. Kaufman or iiwasan niya. Yung admissions that former president made during the hearings before the House of Representatives and Senate, because they were all they were all made under oath. Nanumpa siya dun. Di ba sabi niya, no need for any affidavit because my statements here were all received, no? They were all made under oath kasi nanumpa siya eh. So, ang tanong natin, iiwasan ba ni Kaufman yung admissions? Kasi iba yung admissions niya sa Senado at saka sa House. Diba? Ibang mga, hindi pwedeng sabihin is just political hyperbole lang. Diba? Hindi pwedeng sabihin na exaggeration lang yung ginawa niya sa Senate, sa House. Kasi under oath yun. Maybe sa speeches, kasi sabihin, nangangampanya lang yan, nagpapakitang gilas lang yan sa mga kababayan. Pero kung under oath ka, and he knows that because he's a lawyer. Diba? He knows the effect of the statements made under oath. Kaya nga pinapa-under oath eh. Diba? Kaya nga, nung una si VP Sara, yung mag-oath, napilitan lang siya nung tungkol kay Zuleika Lopez eh. Nung na-involved na, diba? So, the rest, hindi naman siya nag-under oath, diba? So, yun. So, yun pala mga krim, marami siyang sinabi, pero karamihan doon ay puro sinabi lang niya na walang koneksyon ang mga sinasabi ni dating Pangulong Duterte sa mga naging patayan. Dapat kumbaga makonect. According to Atty. Kaufman, hindi nako-connect. Yun lang. So far, yun ang pinaka-gist niya, yung pinaka-summary ng sinabi niya. So yun, sabi ko nga, bago magkaroon ng break, na bakit daw nga yung prosecution hindi hinighlights ito na sinabi, ba? Part naman to ng evidence ng prosecution na lahat ito ginagawa based sa law at walang paglabag sa batas. So, doon pa lang mga clear, doon pa lang. So far. So, yun lang ang nalista natin at yun na naman yung summary so far. Mayroon pa naman mga clear, no? So, hindi ko alam kung gagamitin niya yung sinabi ni attorney may sinabi si attorney Panelo. Sabi niya yung word ng neutrals daw, it means to prosecute. Hindi naman daw literally pumatay. Diba mga ka-clear? Pero kung iisipin mo, kaya lang syempre hindi naman nila witness eh. Diba? Sa ngayon mga ka-clear, hindi pa siya dumidepensa eh. It's more on part of the defense na to, pero ibig sabihin yung ito ebidensya ko, hindi pa siya doon. More on ginigiba niya lang yung mga statements. Well, ganoon naman talaga minsan sa accused, gigibain mo talaga yung statements. Pero mas maganda kung hindi lang paggiba, di ba, na parang pinapahina mo na statements. Pero kasi, merong kasing proof eh. Meron kasi talagang namatay. Diba? Hindi ko alam kung magiging witness nila si Dr. Fortune na sinabi niya, di ba, karamihan sa mga naging biktima ay close range ang tama at ang nakakalungkot according to him, according to her, Dr. Fortune pala, yung babae, according to her, may dinodoktor man na mga death certificate na instead na sabihin na talagang nabarel, ang nakita niyang iba, dinoktor. Nilagay na ang pagkamatay ay sepsis. Diba? Yung parang yung sepsis, diba parang infection sa dugo. Parang ganun. So, yun. So, di ko alam, parang hindi ko nadinig siya sa prosecution. Diba? Maganda yun eh. Magandang maganda sana ebidensya yun. Kasi kung napatay, part ito ng tokhang or EJK, operation ng police, tapos napakita ang tama sa ulo, tapos yung death certificate nun ay dinoktor. Di ba? Medyo okay na yun. Vencier, di ba? Tatay G, Sherry Banyaga. Yan. Pero sa forensic, may tama ng baril. So, di ko alam. Sorry mga clear. Sa 2 araw, di ko siya masyado nadinig kung meron patungkol doon. Baka na-miss ko siya, pero hindi ko kasi siya nadinig. No? Pero sinabi nila, meron akong alam na sinabi ng prosecution na close range. Yung pang second day, yung bago si Atty. Andresa, may unang may babae, si Atty. Croft ba yun, or Prosecutor Croft, tapos meron pang isa para sa lawyer for the victims. Dalawa kasi sila eh, bago si Atty. Andres, meron pa isa. Yon, nagbanggit yun about yung tama na close range. Yan, hindi ko lang alam kung meron ba siya, parang hindi ko napansin kung may pinakita siya na mga medical certificate. Pero at least nabanggit niya. Pero yun lang. Di ba mas okay sana na itong taong to, itong sinasabi na to, ang death certificate nito, tumugma, may operation ng police, tapos close range. So, well, di natin alam kung may strategy ba ang prosecution, kung kailan ito papakita, kasi this is pa lang confirmation of charges. Kumbaga, hindi pa naman ito talaga in full na ipipresent mo lahat yung mga witnesses. So, let us see. So far, mga clear, so magpapaalam muna ako kasi meron tayong inaasikaso pa. Pero babalik tayo mga clear. So, yun lang muna tayo, ang explanation natin. So, maraming salamat sa lahat ng sumama sa atin dito. Medyo nalitan ko ng konti, gagagaling ko lang sa opisina. So, yun, mga ka-clear. So, mamaya, magkita-kita tayo ulit, ha? Sana nandyan pa rin kayo. Pag start ulit niya, titignan ko lang. Okay, may interview lang po kasi tayo. Okay, see you in a while. Bye-bye. Thank you so much. Don't forget to like, share, and subscribe. Salamat po.